JCJ. Yes, I repeat. Good evening to the aspirants of the JCJ 2022 main examination. And yesterday I was dealing the section 14, and today is the continuation of the same. Yes, participants, read what I posted on the screen. It is gone.
Every bad situation will.
Here.
Welcome to the aspirants of JCJ 2022 main examination, section 14 of Specific Relief Act.
Yes.
Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Monza, Tanzania. There is one correction to be done.
Yes.
Can you go back to the earlier slide, the main slide?
Okay. Let me minimize it. Okay, now tell me.
Specific, S is capital, relief is small. It's R. R should be capital and A should be capital.
Yes, that is actually the observation of a lawyer. See, I thought of changing it. I said, time is up. No, better we'll make it out. Then we'll make in the correction while going on.
Later on we can make it out. Only we both are there.
So with that view only that I escaped it. Otherwise, I would have to ask him what is the mistake over there. Yes, now in my last class we are dealing about a tenant. After tenancy is there, we did it. And debentures we are discussing at the time.
Yes. Debentures over.
Yeah. So debentures are over. Then because of the case law, employment contracts, yes, he can give the notice and he can terminate it. Only the government employees who are working in the public sector, it is very difficult to remove them or terminate them. This oil corporation, Amritsar gas service, yes, distribution, he wants, he can retain it. If he doesn't want, he can hold it, revoke the license also. Or in the middle also he can revoke it, provided he would violate any one of the conditions over there for the granting the license.
Yes.
Like mixing the petrol with the gasoline.
Some oil.
Oil.
Or giving less petrol.
Yeah, any manipulation.
Any manipulation.
So that also we did it, and we are, I believe, contracts requirement for the constant supervision. Yes, we also did this one because it's the Ryan Mutual Taunton Westminster Chambers Association. The court has refused specifically to enforce any undertaking by the lessor of services flat to have a porter constantly in attendance. Means a porter will be constantly attending to him, and the porter is not over there. We cannot make the specific relief at the time because it's a third person activity that we are making it. Railroad also we dealt it because we discussed level crossing, unmanned level crossing and level crossing. Am I right?
Yes.
And then I think we are in this place because where is the debentures? Because we discussed the debentures. And a governing contract for the construction. Section 14, subsection 3, class C. In regard to the construction agreements, the principle embodied in the English law have been adopted by the subsection 3 of the class C. When the building is of exact nature, the plaintiff has a substantial interest in the work, and the work is of such a nature that it cannot be compensated in terms of the money, and the defendant in possession of the whole or part of the site. Regarding the building contracts are concerned, he says, I will give the double of the amount. But the person who paid in the beginning the half of the amount at the foundation time, he say, I don't need the money, I want the flat.
Yes.
Because he spent the money at the time of the construction, the foundation only. Now, after construction, he will say, whatever the amount, double I will pay you. But he says, no, sir, I don't want double because I know the rate of the house at that place, because it takes at least 1 to 2 years, 2 years to 3 years. At least minimum 1 year or 1.5 years. A good
Yes.
construction takes the time.
But nowadays, what builders do is that after the RERA coming into picture,
Okay.
there's a separate act for this RERA,
Okay.
Real Estate Regulation Act, which
Okay.
includes all the housing constructions and all these things.
But the curing takes a lot of time, no?
No, no, that's true. That's true. That's true. That's why what these people, contractors, they do,
Mm-hmm.
whenever they make any building or when they're
Mm-hmm.
constructing any apartment, anything, with little bit
Okay.
multi-storied or anything,
Okay.
they have to notify to the concerned authority, RERA authority,
Okay.
stating that this building is going to be completed in next 5 years by so and so date, and the position will be given on so and so date.
Means in advance they will notify it.
Yes, yes, yes. That is compulsory now. It is
I
called RERA.
see.
In Maharashtra, it is called Maharera. In Telangana, each state has RERA. Only thing is
Acha,
that the
acha.
name changes. Telangana RERA, Maharera, AP RERA, it is called as.
My
But
goodness, this I did not have an idea.
there's a law, RERA, Real Estate Regulation Act, which is more powerful.
Acha, 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 acha.
One of my neighbor, in fact, in
Okay.
Bombay, he paid money when 10 years back, 15 years, 11 years back.
My goodness.
And that builder, he didn't do any construction.
Uh-huh.
He has done construction, but he was supposed to give the apartment in next 4 years.
Okay.
In 2011, he gave money,
Okay.
January. He was supposed to hand over by 2015, 14,
Okay.
15 like that. Today is what, 2022.
My goodness.
So he has not given them. So we went into RERA, we fought it. Then the builder lost the case. The tribunal ordered compensation.
With the
That
interest.
person did not pay money, builder. Then
Mhm.
again, I went again on. Once the order came, I went into execution of that order.
Very good.
Then I told the tribunal that this person has blatantly violated all the norms, all the court's orders. So
Okay.
his property should be attached.
अच्छा 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 अच्छा
तो
अच्छा अच्छा.
ट्रिब्यूनल ने तुरंत ऑर्डर दिया, अटैच करो प्रॉपर्टी को.
My goodness.
जैसे अटैच किया प्रॉपर्टी को, तुरंत सबको बुलाया, भाई तुम लोग आके तुम्हारा पैसे लेके जाओ. बिकॉज क्या होता है मालूम, वंस द प्रॉपर्टी इज अटैच,
Yeah, 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 yeah.
द ट्रिब्यूनल
He
गिव ऑर्डर टू
will
द कोर्ट.
have a bad stigma in the market.
नॉट स्टिग्मा. स्टिग्मा तो छोड़िए सर.
Okay.
दैट ऑर्डर विल गो टू द डिस्ट्रिक्ट कलेक्टर.
Okay.
District collector under the revenue and land, this thing, he will take over that property.
अच्छा 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 अच्छा.
एक बार वंस एक बार सरकार का हाथ में प्रॉपर्टी गया तो क्या हाल होने वाला.
खत्म खत्म आउट. एक बार लारी पुलिस वाले पकड़ लिए बनफ.
एंड हियर कलेक्टर ले लिया, वो तो आपको कोर्ट का चक्कर काटना पड़ेगा. सरकार तो आज देंगे, कल देंगे, वो आज कल इसका जिंदगी निकल जाएगा.
Yes, 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 yes.
So once that goes, then what the collector does, he puts that land on sale.
अच्छा 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 अच्छा.
हाँ, उसमें जो पैसा आता है, then he distributes to everyone
Okay, okay,
as per the
okay.
court order.
But
So
he called all the people and gave the money.
yes, all the people.
With the court directions, the
With the
same
court direct.
of the type of interest.
Yes, with the interest, everything. Because I was
Okay.
party to that. One of my friend का तो मैं ही खुद I was arguing his case.
Execution of the order.
Yes, तो
So
फिर
the
बाद
practical
में.
way that you know that how and we can get the money and how
Yes,
it will take the pain to get the money, even the court has decreed the matter.
yes. रेरा का बहुत ये है, but उसमें और एक condition है.
Yes.
If I have booked a flat
Okay.
and let's say the flat cost value is 1 crore.
Okay.
अगर मैंने 20 लाख रुपए एडवांस में दे दिया, बुक कर
Okay.
लिया, 20 या
Okay.
10 लाख जो भी दिया है, बुक कर लिया.
Right.
So there is, and suddenly I want to withdraw from the project.
Right.
And I'll tell, I don't want to continue the project, please refund my 10 lakhs.
Okay.
The RERA tribunal has powers either to say that you will not get any penny,
Okay.
10 लाख भूल जाओ आप,
Okay.
or else अगर बिल्डर ने कुछ अग्रीमेंट में लिखा है, in course
Okay.
of as per the situation of the work, उसका 10%, 20% हम काटेंगे, then accordingly he'll deduct and give that amount.
Okay. Okay. Right.
अगर मान ले फाउंडेशन तक हुआ है, उसके लिए 10% देना पड़ेगा आपको, फिर फाउंडेशन से
Depending
और ऊपर आएगा.
upon the quantum merit.
फिर उसका हिसाब से then you have to pay money and get out from the project.
Okay, okay.
So there are two things.
Mm-hmm.
There's that.
Because even that fellow also, he will be helpless, no, if somebody revoke in the middle.
Yeah, he will not. Of course, he will not be helpless. उसको तो खरीदने वाले बहुत लोग मिलेंगे उसको.
Okay,
He can sell it at the present rate.
okay,
अगर
right,
मैं
right.
4 साल पहले जो खरीदा है,
Yes, yes, yes.
and if I'm buying it today, there is an increase in the price.
Definitely, definitely.
There is, and plus, this person will already deduct 10% or 20%, whatever,
That
as
also
per
a
the
bit
agreement.
profit to him.
It profit. And if the matter goes to the court, court सीधा बोल देता है तुमको कुछ नहीं मिलेगा, जो 20 लाख दिया भूल जाओ बोलेगा उसको.
बिल्कुल भूल जाओ, because there is no such a provision would be there. You can make a breach of a contract in the middle.
Yes, तो क्या हुआ, बिल्डर को तो प्रॉफिट है.
In addition to that, that he will, if at all it returns after deducting 10 or 20%, he will return it.
Yes, so there are two ways. But yeah, people getting out of the project is very less.
Okay.
But project खत्म नहीं होना time पे, that's a big story.
Okay. So let us see the case law here. Her Highness Maharani Shanti Devi versus Shanti Devi P. Gaikwad versus Shivaji Bhai Hari Bhai Patel. The Supreme Court observed that the authority that had to supervise the performance of the contract had ceased to exist. Okay, those who are supervising the contract has ceased to exist.
But I fail to understand.
Okay.
This, why did they write Highness?
At the time, they.
No, but this is in 2001.
She is a princess.
No, but this is in 2001. But if you looked into the after the independence,
yeah, this is the
all designations of Maharani, Maharaja, all have been thrown out.
Yes, yes, but it is as I told you, no. Land तो चलेगा, lord रहेगा. Is it not?
सही है, sir.
So all the kingdom have gone, but Highness is left. So Her Highness Maharani Shanti Devi P. Gaikwad versus Shivaji Bhai Hari Bhai Patel 2001 case law. The Supreme Court observed that the authority that had to supervise the performance of the contract had ceased to exist. Then what it stated? In addition, the contention that the government agreement is not specifically enforceable under Clause D of the subsection 1 of the Section 14 of the Specific Relief Act 1963 has some merit. And a contract that involves a continuous work that cannot be supervised by the court is ineligible for the specific enforcement in this provision. Like a supervision of the everyday work, if it is given as such a thing, perhaps either his health is not good, he did not supervise, or any unnatural thing happens over there where the work is stopped for such a thing, the court reluctant to give the specific performance.
Or due to some government norms, changes
Yeah,
in
yeah,
government.
because of the various other factors, no.
Which is not beyond his which is something
beyond his control.
Yes.
So considering the nature of the scheme and the facts and circumstances of the case, it is clear that the performance of the contract requires continuous supervision, which the court cannot perform. The competent authority is no longer required to conduct such ongoing monitoring since it does not exist after the repeal. So once a continuous supervision would be there for the development or for the progress of the contract, such a things, it is difficult to give an order for the specific performance. Of course, such orders will be repealed because one cannot have the continuous supervision for that a particular activity. So in the case of Envision Engineering versus Sachin Infra Environment, so not environment, Enviro, 2002, it was held that when a contract involved a public project, okay, and the plaintiff was unable to prove any prima facie case against him and his loss could also be quantified in monetary terms. The court refused to grant an injunction restraining the continuation of the public project. See, the public project, I don't think that the court will interfere in that matter.
All government projects and all these things where it is of public interest,
Yes.
the court will normally not interfere in such matters
Okay, okay.
because it is of public nature. Na?
Yeah.
Whatever the government is doing, it's doing for the welfare of the people.
You cannot bring an action against the government.
So how can you take an action against a government unless there is a serious violation of environment or something?
Yeah. At that instance, we can make it out.
Yes.
Otherwise, the government will not issue an injunction order.
Yeah, yes.
Now, arbitration. According to subsection 2 of section 14, an agreement to refer a present or future dispute to arbitration may not be specifically enforced except as provided in the Arbitration Act 1940. Now the Arbitration and Conciliation Act it became in 1996.
Yes.
An arbitration agreement bars the filing a lawsuit. Yes. Once the matter goes to the arbitration, automatically it will bar to go to the civil court. Am I right?
No, it is like this. No, as per the present Arbitration Act,
Okay.
A person cannot go directly under the Arbitration Act.
Okay.
He has to approach the High Court only. Earlier, it was district court. All the courts had powers to appoint an arbitrator.
Okay.
But now the present act, which clearly says only two courts have jurisdiction. One is the Supreme Court and one is the High Court.
To settle the matter in the arbitration.
Yes. The other thing is that whenever there is a matter within India, any matters within India, Indian parties, the High Court has powers.
Achha.
And that matter cannot be referred to Supreme Court.
Okay.
And Supreme Court has power for international arbitration where one party is from other country and other parties of India.
Okay.
Then Supreme Court has powers to appoint an arbitrator.
Right.
So what happens is that both the parties have to give 3 names from their side, 3 names or 2 names.
Okay.
And the court will decide one name. And as per the payment will be done as per the Arbitration Act. The fee structure is laid down in the Arbitration Act.
Okay.
All the fee structure and the fees is very high.
Is it?
Very, very high. I mean, आप देखेंगे तो पागल हो जाएंगे.
Achha.
It is very high. And if one arbitrator is appointed, so if a single arbitrator is appointed and if he come to a conclusion, and he gives his judgment or award or whatever you call it, order.
Okay.
Based on the pecuniary amount, whatever the amount awarded is given, he'll collect his fees. That is a separate part. Plus, he will collect 0.25 of that award what he is given.
My goodness.
Because he is a single arbitrator.
Achha.
Either you have one single arbitrator, you have 3 single three or 5, but you cannot have 2.
Okay.
एक मेरा आपका बोलेगा तो अलग हो जाएगा, मैटर खत्म हो जाएगा.
Naturally.
So wherever there is single arbitrator, so he takes his fees plus he takes 0.25 of the on the amount what awarded is given to him.
Oh, that is a proportionate amount.
Yes. And
in a percentage manner.
Yes. And other thing is that arbitration has to be completed within 1 year.
Okay, that is a time stipulation also be there.
Yes. There is a stipulation of time limit. The maximum time limit is 1 year. However, in certain times, he can give an extension of 6 months. So, mota dekha jayega to 1 year, 6 months, he should complete the entire proceedings. That is Arbitration and Conciliation Act.
Right. Now let us see this case law. Amisetti Chandram versus Chodasani Suryanarayana. It is a 2002 case law. The vendor was not allowed to raise the plea that the sale deed was executed under the distress in his second appeal, since the plea was not raised in his written statement and that was a factual issue. Moreover, the court found that there was a lawful basis for the sale agreement. The plea that the decree would cause hardship to him, he was not entertained at this point. Can you explain this point here a little bit? Read
Now,
this.
what this person wants to say is that
Okay.
uh, he sold this property under distress.
Means by forcefully.
By forcefully होगा शायद अभी बोलते हैं ना ऐसे what you call sale में कम पैसे में we get materials.
Okay.
Sale is what? Sale is distress, na?
Yes, yeah, yeah. Sale is a distress. In one
Distress.
way, in another way, unless he is having the many buildings.
Sale. So this person says that the sale agreement is good under distress or whatever it is.
Okay.
Maybe under pressure or under gunpoint or
Yes.
threaten, whatever it is that.
Okay.
So when he appealed for the first time, he was not entertained by the court.
Okay.
So in his second appeal,
Uh-huh.
he raised the issue in his written statement, in his reply.
Okay. Now I got the point. Now I got the
In
point.
the first appeal, he was not entertained, but in the second appeal,
He can
he made
make the.
yes. But I don't know why this person has not made amendment of plea in the first instance only.
Yes, and naturally he can make it out, no?
Had he made it out, it's up to the court whether to take it or not to take it.
But he can raise the issue.
Yes. I don't know whose advocate who encouraged him to do all these things.
ऐसा रहता, the डर, the fear, it will be not for a longer time. It is the fear is only for some time. After that, again the same thing will be routine.
So if you ask me, he should have made an amendment application.
Yeah. He can make it out. In case of the sale is in distress at the time, and in the pendency of the court,
Even
case, he can
even
make
there's a
an
provision. Yes. Even there's a provision in contract also for distress sale.
Okay. So
Anyway.
now it is clear. The court found that there was a lawful basis for the sale agreement because it is sold in the first in the distress.
Yes.
So the plea that the decree could cause hardship to him as well not entertain at his point. Suppose if they not entertain the second point, naturally that fellow will suicide.
Yes.
Is it or not?
Yes.
Because with the life and property, he constructed the house. Even for our also, when you stayed a house for more than 30 to 50 years, forefathers, in such a house, when you are living it, naturally you feel some sad.
Yeah, but as per order 6 rule 17, you can make amendment plea even after the evidence cross-examination, even before that this thing also, what you call judgment.
Achha. But it is only in the lower court. It is only in the lower courts happen all this.
It's in the lower court.
Not in the high court.
High court you have to show that other facts, and when you go in for revision or appeal, you have to show
the causes,
the point of rule of law and the facts, unless you're not going for revision.
Okay. So now in the case of Muhammad Abdul Hakim versus Nayaz Ahmed 2004 case law, a contract that was signed only by the vendor and not signed by the vendor's customer has been deemed a concluded contract.
Deemed.
They deemed hai wo, not signed by the vendor's customer. The court ruled consensus ad idem, means identity of the mind, was necessary for the enforceability.
Yes.
On the strength of the oral agreement, a suit for specific performance can be maintained. Okay. Even for the oral agreement also.
बट सामने वाला बोलेगा हमारा कुछ एग्रीमेंट हुआ नहीं. अगर सामने वाला हाँ हमने एग्री हुआ तो अलग बात है, वो मेंटेनेबल है. अगर सामने वाला बोलेगा मैं किया ही नहीं बोलेगा तो कहाँ से मेंटेनेबल होगा?
That anyway, that's any transaction should be put it in black and white.
It should be reduced to writing.
So that is the point. Generally, we'll make it out. In the case of the Sachitananda Banerjee versus Moli Gupta, a lady established a trust. The trust deed appointed 2 joint trustees.
Mm.
She did, however, act as a trustee on behalf of the trust and enter into a sales agreement. As a result, the agreement was in a breach of the trust and exceeded the trustee's authority. The
Mm.
specific enforcement action could not be pursued by the buyer
Mm.
because it is ultra virus. Am I right?
Yes, yes, yes.
Because the trustee doesn't have such a power which is there in the Trustee Act. And if
Yes.
it exceeds the trustee's authority, at that instance, specific enforcement cannot be maintained and
Yeah.
pursued by the buyer.
Even as per the recent Supreme Court judgment,
Okay,
any land which belongs to the trust,
okay.
no trustee has authority to sell that.
What about the Waqf land?
I have not read Waqf board land up till now. Zyada
Because
nahi padha
I
maine.
saw the viral.
Mm.
You know this, of course, I am not criticizing. The cheetahs came from the Namibia.
Ha, 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 ha.
They, they left over the forest, which is open,
Mm.
and they said it is a Waqf land.
Arey baap re baap.
I don't know whether it is true or not. So the cheetahs wants to go back because they want the free land
Yes, 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 yes.
and nobody would be the owner except the government.
Government.
And their environment is different from the environment in India.
Yes,
You know,
that's true. That's true.
we saw of course, there is no tigers in the South Africa,
Okay.
not in the African continent.
In India, we have.
Only tigers famous for India.
Yes.
But all the things are lions and lioness.
Ah.
And we saw the real hunting of the lion
Arey baap re baap.
or the prey.
Oh.
Yes, because when they are full, they don't do anything. Even though a stag or a lady or a jinka, whatever you call it, go in passes in front of the lion or lioness. Because when they are hunger, at that time only they will
They hunt.
hunt. Otherwise, they never hunt.
Mm.
No,
Yes, yes, yes.
because I saw it, because openly we can see it, and these wild cats doesn't know the taste of a human being. They never kill
Ah.
because there's a plenty of praise are there. They
Mm.
enjoy it, and moreover, they will be very fond of running animal and attacking it.
Attacking them. The more you run, there's a taste in that.
Yes,
The
yes.
more you run,
Blood
your blood gets
circulation is
hot. Your blood, जो खून रहता है ना वो गर्म रहता है वो.
garam रहता, and they enjoy that.
ये गर्म खून खाने में उनको अच्छा लगता है.
Yeah, that is actually the thing.
Hmm.
इसलिए बोलते ना भगा के मारता.
Hmm.
So that was the thing actually which is happened over there. The same thing. What about this property of these Purohits?
I'm telling.
Trust.
Yes, yes. Any trust, any
Temple.
any temple which is in the name of the trust. Any temple which is in the name of the trust.
Okay.
एग्जाम्पल वेणुनाथ ट्रस्ट एक ट्रस्ट खोल के रखा मैंने.
Okay.
और एक ट्रस्ट का नाम पे मैंने एक प्रॉपर्टी खरीदा है.
Okay.
और प्रॉपर्टी में मंदिर बनाया. या
Okay.
कुछ अनाथ आश्रम बनाया.
Okay.
कुछ भी बनाया मैंने.
Okay.
So that property cannot be sold to anyone and no one has authority to buy that trust land.
Okay.
वो ट्रस्ट का लैंड, ट्रस्ट इज द ओनर, पुजारी इज नॉट द ओनर.
अच्छा अच्छा अच्छा.
सुप्रीम कोर्ट का जजमेंट है, सुप्रीम कोर्ट का क्लियर है.
Mhm.
Pujari is not the owner. Pujari is only to do
Custodian.
prayers. Only to do prayers. That's all.
Mhm. Then
He
what about
cannot
the
sell the
next
land.
pujari? After the pujari's death?
No one has right.
No. Purohit should be from the same clan, father, forefathers from the same.
No. ऐसा भी नहीं. There was some. There was a case law which was I was referring to one famous Hindu temple in north. I think Katra में वैष्णव देवी temple.
Okay.
There was a family which were doing pujas for generations.
Yes.
So did these people did some mismanagement of money, some siphon of funds.
अच्छा अच्छा
तो
अच्छा अच्छा
गवर्नमेंट ने किसी और लोगों को आके बिठा के वो चला पूजा वीजा के किया है.
अच्छा 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 अच्छा.
That was challenged in the court of law,
Okay.
but it went against the trust people. They said that doing puja for generation, it is not your birthright. You have been given that this thing to do, but
Okay.
since you have done all these things,
It is not heredity.
yes, it is not hereditary.
Mm-hmm.
ऐसा है वो.
Okay, now I got the point because, but that property cannot be sold.
Yes, that property cannot be sold, and even uh, nowadays you see this in apartments. You have this place for garden.
Yeah,
गार्डन के लिए एक जगह बना के रखते हैं ना.
बिल्कुल community hall, garden, a playground.
हाँ, community hall, especially garden.
Okay, garden that cannot be used for any other purposes
That
except the
cannot be
garden.
used except for garden. You cannot use it for any other purpose. Kalke then you say, oh, I'm going for redevelopment. You do anything, but don't touch that garden place.
Okay, okay, no, I got it. Got the point.
ऐसा
Now,
ही.
family settlement. Can the family settlement court will interfere
No, sir, normally what happens is that the court normally gives chance to all the parties as far as families are concerned. When
to
there's any issue.
represent?
To representment, and it will give time also, but you all settle the matter internally and come up with some solution.
Okay, okay,
Before we enter in and we give in some judgment to you,
okay.
which you may like, you may not like, and once the court gives judgment, it is binding on all the parties
Naturally.
by default. So what the court says is, you all on your own settle matter, come with a solution.
Suppose if they settle the matter, court will endorse it and stamp it.
Yes. Once they come and settle the matter, you make an application of terms and conditions, settlement of terms and conditions in the
Okay,
court. All the parties will sign.
definitely with the witnesses.
Yes, all the parties will sign. And once that is submitted in the court will see क्या है, कैसे correct है, क्या है. Okay,
Do they
done.
ask the question to the other party?
No, what the court does is that it will call each and every party
Okay.
to the court. This agreement has been signed. Are you happy? Are you okay with this agreement? You are getting so much land, whereas you have claimed so much of land in your
But
petition.
you are compromised with only with this one.
Yeah, it will definitely ask. It will definitely. The court has the right, and it is a duty of the court to question why have you settled in the low premium or low land or whatever it is that.
They want to hear from the horse mouth.
Yes. Once all the people who are there for settlement, if they say no, we agree, we are in agreement, then the court will say okay. So Harek party ko the court definitely will ask.
Then they will endorse it.
Then they'll endorse it.
And that is a judgment.
That is a judgment. Then the court will clearly write. This judgment is based on the settlement between the parties.
Okay, okay.
So tomorrow they should not come and say court ne humko ye diya settlement.
No, because it's agreed by the parties only.
Yes.
So merely the settlement that is.
Yes.
So here Kanigolla Lakshmana Rao versus Gudimetla Ratna Manikyamba. It was observed that the agreement for the transfer of property, which was deemed to be a part of the settlement, was not devoid of consideration. The settlement itself is a factor to consider. Of course, when the settlement would be there, naturally, they may not question what is the sufficient consideration.
Yes.
A deed of settlement was produced. It contained the provision for the transfer in question. It could not be said that there was no proof of the settlement. The court ruled it was decided to pass a specific performance decree. There is no proof that it is a settlement. At that instant, the court will interfere. Am I right?
Yes.
It was decided to pass a specific performance of decree.
Yes.
A little question would be there. Sometimes they say court order. Sometimes we say court decree. In the civil matters, can you say the money matter, we can say decree?
Sir, decree, order, judgment.
Yeah.
तीनों अलग-अलग चीज है सर.
Okay.
What happens is that whenever a person goes order.
Okay.
Whenever a person goes to write an exam,
Yes.
there are some certain rules and regulations.
Regulations.
मैं कल एग्जाम लिखने जा रहा हूँ उसका अंदर रहता है, you should reach the center by 9 o'clock. You should
Yes,
carry
yes.
your
Everything,
pen,
everything will be
paper,
written.
pen, paper.
Instruction to
That is
students.
instructions. That is called order.
अच्छा 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 अच्छा
Decree is once you get your marks after आपने एग्जाम लिखा है,
लिखा है
अब लिखने के बाद कुछ तो मार्क्स मिलेगा, 1 मिलेगा, 2 मिलेगा,
एक
10
जीरो
मिलेगा,
तो मिलेगा ना
कुछ तो मिलेगा उसको.
या
That tells you got so much marks. That is called decree.
ओके ओके
And judgment is like once you get your result, you get a certificate that you have passed.
oh that is authentic proof
That is called judgment.
that is called judgment
Yes.
so that's why you should wait for the judgment copy should reach it then only you can go to the appeal
Yes. 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 Yes.
now I got it very much clear but I appreciate your way of teaching
सर आपने सिखाया मेरे को, मैं किधर सीखा सर.
yeah
आपसे
yeah
सीख
yeah
के
yeah I appreciate sometimes now we'll get the confusion but now the confusion is over
yes yes मैं आपसे सीखा and I read lot of judgment also. So
yes
court से
yes
judgment पढ़ता
because
रहता हूँ मैं.
practice make it no for you to read the for one case you have to refer the so many cases so many books
In
so
one
the
of my
conclusion
recent
is
Hmm.
whenever a person is according to the spirit of the contractual rest
Hmm.
the voluntary action of the parties
Yes.
or when the act stipulated requires specific knowledge or skills or ability or experience
Hmm.
of course we cannot enforce it because when the person died is a good painter can you enforce him
No,
can you
how can you
enforce his
enforce it?
wife to make the painting answer
You
is
cannot
no
enforce. Uh,
even though the wife is more popular than the husband
uh,
in painting.
but the contract is given to the husband, not to the wife.
So, actio personalis maritam cum persona. A personal action of a person dies with the person.
Yes, yes, yes,
So, that maxim would be applied, no specific performance.
yes.
Or the exercise of the judgment or discretion, integrity, and like personal qualities in brief.
Hmm.
When there is a discretion is there, we cannot ask for the specific performance.
Yes, yes.
If the performance according to the spirit of the contract is dependent upon the individual will and the capacity of the contracting parties, a court cannot impose the performance.
Hmm.
So there are rules are there. By that only the court will feel that yes, there will be irreparable loss to the plaintiff, and hence
Yes.
specific performance could be undertaken.
Hmm.
The following contracts are not enforceable under the Section 14 of the Act. So if anybody asks, Section 14 says contract should be performed or contract should not be performed.
Hmm.
So here, contract not enforceable.
Yes.
So the contract that provides the compensation in the form of a money is an adequate relief. No specific performance could be asked. That is
Yes.
A. B. Contract that requires a personal service. Definitely, the painter is died. We cannot ask his son or wife or children to paint,
Yes.
even though they are more better than the deceased.
Yes.
See, contract with the unclear terms.
Ambiguity
Yes,
terms रहते हैं ना.
ambiguity is there. Concessory addendum.
Hmm.
अरे मैं घर बेचता हूँ बोला ना यस बेचता हूँ बोला अरे उसके 10 घर आए 10 houses he is having which
कौन
घर
सा घर? कौन सा घर?
so that would be very much clearly identity of the mind consensus addendum. So the clear term should be the D. Contract by the nature and determinable. What is the type of the contract? Whether it is a justification go for the specific performance or not.
You cannot sell something. You cannot sell something which is not in your control.
Naturally.
ताजमहल दिखा के मैं ये बेचता हूँ बोल के नहीं चलेगा ना.
It is not the property of your individual. I think is it the endowment or archaeology department?
Archaeology.
It is archaeology department. To
Only
take care.
temples comes under endowment.
Achha, temples come under endowment. Okay,
Only
okay,
temples comes under
okay.
endowment. All other
See,
forts.
this time now I went for the Taj Mahal. Now everything is online.
Tickets ka?
Even you can buy the ticket online.
Yes.
You need not to stand in the queue.
Yes.
They made online such a thing. They already the ticket was there, and just you can go enter because there is a swiping system there. There is a what is swiping is different. Sensor system.
Sensor.
Sensor is there. Just you put the coin over there. Sensor. Can now you tell me what is the gate? The gate is specific name is there.
I have not been to Taj Mahal up till now.
No. Why you Taj Mahal in a metro it is there. When you put the coin, there were three rods are there.
वो
Three rods
तीन
are
डंडा
there.
रहता है, तीन डंडा रहता है ना उसको.
तीन डंडा रहता है उससे.
एयरपोर्ट में
Having
बहुत
a
रहता है.
specific name.
I forgot the name.
Turnstile. Turnstile. Something. I will tell you that. Turnstile gate. A turnstile.
ये ना दिखा images में जाइए सर.
Yeah, turnstile gate, they say.
Turnstile. STILE.
Yeah. But another is a wicket gate. Wicket gate means you go inside, only one person go, then another compartment, another person will go.
वो ऐसा था, वो दो कांच रहता है उसका.
How?
एक्रिलिक कांच जैसा रहता है वो. ओपन करेगा जाएगा फिर बंद होता है वो.
बंद हो जाता है. ये रॉड्स रहते इसके. तो रॉड क्या करता बोले तो it will allow you to go.
Yes.
See, turnstile.
Yes.
So I should appreciate my memory. Very long back I studied this thing, but I want to make the experiment. Turnstile.
I passed many times these gates, but I never recollected इनका नाम क्या होता है बोल के.
Yeah. Turnstile gate, wicket gate. These are types of the gates are available. So, and contracts are not valid in law, cannot be enforced.
Yes.
And contracts requiring the court's continuous supervision. No. A court cannot be a watchman.
Yes.
And contracts for building or repairing works.
Yes.
See, torrential rains are there. Now you tell me.
कैसे करेगा उसका?
People are not going outside and you want the construction should be done. No, even the labor will not work under the such. Inside work, okay, they can do it. But outer work, no. Hindu parents and guardians cannot specifically enforce a contract to give their child in marriage.
Yes.
I think there the succession will come into the picture. Hindu parents and guardians cannot specifically enforce a contract to give their child in marriage.
Yes, this is contract.
Child in the marriage.
This is a contract. बोलते ना भाई तुम हम actually Hindu marriage is also just like a contract only. You give you take my daughter, I'm giving you so much money.
कन्या शुल्कम भी बोलते ना उसे. कन्या शुल्कम.
कन्यादानम.
Kanyadanam and the shulkam will be taken by the bride's father. Parents, we can say.
Yes. But you cannot have any contract for the marriage.
Yeah. At the most, we can ask for the compensation, the amount incurred in preparation or in the printing of the wedding card or buying the advanced essential which are needed for the cooking purposes, but it doesn't be filed under the.
You cannot have any type of contract when it comes to marriage. It's simple funda.
Yes. And I read the Tamil Nadu judgment.
Okay.
The fellow promised her to get married, and that woman got pregnant. Later, he deceived. She challenged it in the court.
Yes.
But the court has given the judgment,
No, it is not cheating. It is not rape.
Even you are conceived, there is no necessity that he should marry you.
There are many court judgments which says all these things. And recently, in one of the thing, I forgot which High Court has given a decision where she has filed a petition under rape, where the person initially he promised her that he will marry her.
Okay.
And later on, he married someone else.
Okay.
and this woman also started having affair with that gentleman even after his marriage,
Knowingly.
knowingly.
Mhm.
The court said even after the
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मागे। गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
We live in a world full